You are too fast for me. Answer. You're too fast.
Alex,
You know I'm
Alex,
writing.
please. Alex,
You're too
please. I'm
fast for
sorry
me.
about that. I'm sorry.
Oh,
I'm
yeah,
sorry.
yes, then you continue.
Okay, sir.
We're
So
out of time.
yeah, we're out
And
of time. Yeah.
uh, uh, just hold on. They have filed a motion on notice.
Yes, sir.
Motion on notice to regularize him.
Yes, sir.
The motion on notice dated when placed? Dated
Dated the
dated when?
28th day of February, sir, 2024. 28th February, 2024.
Filed
Filed
when?
same date, sir.
Is it
20,
filed on the same date?
28th of February. Yes, sir. Yes, sir. Yes, sir. It is filed on the same date. I don't know if my lord can hear me. It is filed on the same date. My lord, sir. I don't know if my lord can hear me. It is filed on the same 28th of February.
Okay, gentlemen. Hello. I believe you can hear me.
Yes, my lord, we can hear you.
Please continue. It's due to network interruption. So
As the call pleases.
you
So the
can
motion
just
is dated 28th of February, 2024, and
find
filed
on the
same
same
date.
date.
Yes, sir.
Okay.
Yes, sir. The motion seeks the leave of the since and
And
all
since
that.
the claimant's counsel said he's not opposing, let us
Yes,
move
sir.
in terms of the application in order for
As
us to
the,
see.
as the court pleases, I move in terms of application dated 28th of February 2024 and urge the court to grant same. We are grateful, sir.
You're welcome.
Yes.
Mr. Done it, done it. Need to move in terms of the motion paper. Since order has prayed.
The court pleases. We are grateful.
Yes, time for adoption now.
Yes, sir.
Adoption.
So the defendant counsel will adopt first, sir.
Yes, ma'am. That's why I said adoption.
Yes.
Mr. AK. No. Mr. AK, adoption. I cannot hear.
Mr. K is here. He's
Hey,
here.
Mr. AK, I can't hear his voice.
Let him unmute. Mr. K, kindly unmute. He's still
Mr. AK,
muted.
unmute.
Wow.
Hello, my lord.
Yes, please.
Okay, my lord, the defendants, so counterclaimant's final address is dated the 7th of August 2023.
Just take it slowly. You know I'm writing in longhand.
Yes, my lord.
Claimant, counterclaimant, final
written address
written
is dated and filed on the 7th day of August 2023, my lord.
Yes, please.
My lord, in the said final address, two issues were raised by the defendant.
Maybe you should adopt first before you. Maybe you should adopt first before you adopt.
My lord?
I think it's important for you to adopt first before the adopt.
The defendant counterclaimer hereby adopt its final written address dated and filed on the 7th of August 2023, and we urge my lord to dismiss the claimant's claims against the defendant. We urge my lord to dismiss the claimant's claims against the defendant, and in its place enter judgment in favor of the defendant's counterclaimant in terms of the counterclaim. We urge my lord to enter judgment in favor of the counterclaimant in terms of the counterclaim against the claimant, my lord.
Yes, please.
My lord, in the said final written address, my lord, two issues were raised.
Okay, that's adoption.
Yes, my lord. Two issues were raised. My lord, I'll just be very quick, because my lord, this is a Zoom hearing. Two issues were raised.
I will still have so much work to do.
My lord, the two issues can be found at page 10 of the final written address. The two issues will be found at page 10 of the final written address.
Yes.
My lord, I take them as having been read.
Yes.
My lord, arguments and submission in respect of issue number 1 could be found at pages 10 to 18. Argument and submission in respect of issue number 1 could be found at pages 10 to 18 of the final written address.
Yes, let's say the arguments are contained therein. So,
yes, my lord.
I think let's say the arguments are contained therein.
Yes, the arguments
are contained
in the written address, my lord.
Yes, yes.
Yes, my lord. And the argument and submissions in respect of issue number 2 could also be found at pages 19 to 29 of the written address. And my Lord, we urge my Lord to kindly go through same and dismiss the claim of the claimant and enter judgment in favor of the defendant counterclaim. My Lord will find out, my Lord, just one point, my Lord. My Lord will find out that the claimant did not file written address. So he did not file, but did not file written statement on oath in respect of
everything is in the written final written address.
My Lord. My Lord, I adopt and I urge my Lord to kindly agree with us and enter judgment in favor of the counterclaimant.
Yes. Yes. Yes, Claimant's Counsel.
Yes, my Lord. The claimant's final written address is dated and filed on the 30th of October, 2023. Dated and filed on the 30th day of October, 2023.
Yes.
We, on behalf of the claimant, wish to adopt the said final written address as our argument in this case. In urging the Honorable Court to grant the reliefs sought by this claimant in this case. And in the same vein, dismiss the counterclaim, to dismiss the counterclaim of the counterclaimant as an afterthought and unproved against this claimant.
Okay. Is that all?
Yes, my Lord. Just in a few adumbration, I would like to refer my lords to the pages where our arguments can be found. We also raised 2 issues for determination.
There's no problem. Don't need to refer me to the pages. I'm not going to go through the entire final written address.
As the court pleases. We humbly urge the court. We humbly urge the court to give judgment in favor of the claimant, having proved our case, and dismiss the counter claim as unproved. We are grateful, sir.
Okay.
Yes, sir.
Yes. Let's put down for judgment.
As the court please.
As the court pleases.
Yes, for the next. No, not that one.
We are grateful, my Lord.
Yes. Okay. That one. That one. Let me have them now. You should not have been the choice. me just put that one aside. Case of, just put them in judgment, so put them in there. Judgment only. Put them. That one. What's the one? This one time. Case of. Okay. Adegboye Akim against United Bank for Africa. Adegboye Akim.
How do I?
Okay, yeah, there. Okay. Just leave
Yes, my lord.
Yes, this one is not headed. Why is it not headed? This one for judgment. Why should it not be headed? Just sorry. Why should it not be headed? Not for judgment. Where's the Not for judgment. It's not this one that was put down. Okay, this one for judgment.
My lord, sir, Adegboye Akim is for adoption of final written addresses.
It's for adoption or for judgment?
For adoption. Adegboye Akim.
Yes, Adegboye Akim. It's for
yes,
adoption.
It's for judgment, my lord.
It's for judgment.
For judgment. Okay. Okay, for it's for judgment, and that means you not. Okay. Okay, I'll check the judgments later.
Okay, sir.
Okay, let me have that. And we should not Mr. Canada this thing. Where's the Andrew right there? No, not this one. The other Andrew right there. You also take this thing. That's why I said I didn't them here. Some mixing. Okay, yeah. Andrew, sorry, I will come to Adegboye. Gentlemen, sorry, I'll come to Adegboye Akim later. Just sort them out. I'll come to that later. See, that is for judgment. So the case of Andrew Agbeha and Obawumi Jiboku and another. People, are you there, please?
Yes, my lord, we are here.
Okay, I think the parties are absent. Appearance, please.
May you please the court? Appearance. May you please the court, my lord? S.C. Umesi. My name is S.C. Umesi. My appearance is for the complainant, my lord.
S.C.
Umesi.
Umesi, yes.
I appear for the complainant.
Complainant or claimant? Complainant or claimant?
Claimant, my lord.
Claimant.
Yes, we appear for the claimant.
Okay. Yes.
Almost of blood.
Okay.
Yes.
May it please this honorable court. R.O. Igbabo. R.O. Igbabo. I want to announce appearance for the defendant. R.O. Igbabo for the defendant, my lord.
Yes. So. Yes.
My lord,
starting with the defendant.
Defendant, yes, my lord. My lord, the defendant filed his final written address dated 25th of July 2023, but filed on the 3rd of August 2023.
My lord,
is dated 25th of July, my lord, 2023, but filed on the 3rd day of August 2023.
4th or 3rd? 4th.
3rd.
Is it 4? August 4?
No, 3rd, okay. My lord. Yes, my lord.
2023.
2023. Yes. My lord, the defense probably adopts him as an argument in respect of this case. and pursuant to the claimant's final written address, the defendant filed a reply on point of law. Our reply on point of law is dated 30th day
take it slowly. Take it slowly. You know I'm writing.
I apologize, my lord.
Just arrange them very well. And then, so you're talking about reply of point of law.
Our reply on point of law, yes, my lord. It is dated 30th day of April, 2024.
Point of law. Dated
30th day of April, 2024.
Okay. Yes.
But it was filed on the 7th day of May, 2024.
Yes.
We humbly adopt same arguments in respect of this case, and we urge your lordship to dismiss the claims of the claimant.
Okay, Claimant's counsel.
As the court pleases, my lord. My lord, the claimant's final written address is dated the 15th of April, 2024.
Yes.
And also filed on that same date, the 15th of April, 2024.
Yes.
My lord, we have enunciated 2 issues for determination by this honorable court.
Yes.
And we seek to adopt our final written address, as our final argument in this matter.
Yes.
My lord, our main argument in this matter, the claimant was not properly, the appointment of the claimant was not properly terminated by the defendants, as contained in Exhibit A, which is the letter of appointment dated the 8th of July, 2010, and contained the terms of engagement between the claimant and the defendant. And also is our contention that
have you not written your contention down?
my lord, we have written it down. Just wanted to add, though we are not served with the defendant's reply on point of law to our final written address. We are not served with that. Maybe could have guided us on making further elaboration on this matter. However, we will adopt our final written address as our argument in this matter, and we will urge this honorable court to grant the relief sought by the claimant in this matter. You are most obliged, my lord.
Yes, you're welcome.
As the court pleases.
Where are the student cases? Separate them, put them aside. Just put that one. Put down. Okay, so case stood down for judgment. You have to hold on. Yes. Case of Uzonna Paul. Uzonna Paul. Uzonna Paul. Okay, you're there. No, I think that just a minute to say. Parties are absent.
Yes, madam.
Yes, appearance, please. Appearance. Yeah, is that only good representation? Next one. Yes, appearance. Appearance. You like that there's no legal representation. The counsel is there with network. Yes. Phone is being something. The network is yes, counsel, what's the problem there? It's network problem.
I think it's network problem.
Network problem.
My noble lord,
Yes, please.
our own matter is for judgment. It's Adegboye Akim and UBA.
No, just hold on, counsel. I just want to know this case now. This one, this the Ozone and Paul's case. It doesn't mean that there's no legal representation there, or the counsel has issues with his network. Okay, I think Sunday.
Yes, sir. Yes, my lord.
Okay, it seems the counsel has some issues with his network.
I'll try to call him. I think.
Okay, I will start down this case. Case is still down. Case is still down.
I'll call the lawyer.
Just call the lawyer so that I can know. So the next case we are doing at the judgment. This no, just hold on. I'm looking at the one. Not this one. Where is that one that's let me have it. Adegboye Akim and UBA. Supposed to be UBA, not UBA. That's it. That I'm waiting on it. Yeah, so Adegboye Akim, appearance, please. Appearance.
May it please, my noble lord.
May the court be please. I'm OB Sonyaolu for the claimants.
It seems I just appeared in the matter for the first time.
Yes, my lord. I'm holding the brief of AA Adejola for the claimants, my lord.
Okay.
Yes, my lord.
Okay. Yes, Defenders Counsel.
May it please, my noble lord.
Yes.
R.O. Morino is my name.
R.
Oh, Morino, my lord.
Morino.
Yes, my lord. I appear with respect for the defendant.
Say pause. We did. This date is 16th of July. 2024 by May. Okay. So So, we'll take the judgment now.
Yes, my lord.
The judgment of this court said that I started by making reference to the claim before the court. It's a 36-page judgment. Page 1, I made reference to the claim before the court, and then some of the first of the facts as presented rather by the defendant. I started with that. Then I summarized the submissions and the final written addresses of the parties, starting with the defendant. Submissions, final written address of the parties, starting with the defendant, and then the claimant. Claimants. But what I'm going is the decision of the court. I'm going to read the decision itself, which is
They have stepped my own down.
The guy said you should try to unmute. Maybe you should call him if you are unmuted. Now you're hearing them.
So, summary of the
I'm hearing from you.
So that takes me to page 29 of the judgment with the court decision. And I said, upon going through the claimant's case, the evidence led in support thereof, and defendant's response thereto, as well as the submissions to the respective final written addresses of the parties. This court is of the view that the issues for determination in this case are as follows. 1, whether claimant has proved that he was wrongly suspended by the defendant. 2, whether the claimant has proved that he was maliciously prosecuted by the defendant. And issue 3, whether from the evidence led before this court, it clearly holds that claimant's account was blocked by the defendant. In respect of issue 1, I said that the settled position of the law is that the contract of employment is the bedrock of any employment relationship, and that the party who voluntarily entered into an employment relationship must comply with the terms of the contract of employment while terminating the said employment or taking any action in respect of the employment. So I've referred to the case of Army Bank Nigeria PLC against Oshisoya and Negi against First Bank of Nigeria PLC, and their citations are stated on the judgment. I also said the law is tried that where an employee claims before the court that the terms of his employment was breached by his employer in any way, he bears the onus to bring the terms of employment before the court and need evidence as to manner of breach before he can be entitled to have the court give judgment in his favor. I've learned on the case of OVA against UBA PLC and United against Opeloye and Briggs against Harris. So their citations are supplied. Claimant has made a case before this court that his suspension by the defendant did not follow his conditions of employment, in that his suspension was done in contravention of the claimant's group human rights, disciplinary process, and sanction policy of June 2010. The facts regarding the suspension of the claimant before this court are that it was placed on the suspension by the defendant via a letter from one Egere Enobong to Mr. Ramola Ayola, claimant supervisor, who was asked to suspend the claimant from his post. And Mr. Ramola informed the claimant verbally that he has been suspended from his position. The reason for the suspension was to enable the defendant to conclude investigations into the allegation of forgery of the claimant's account to the French embassy, allegedly done by him. The claimant was later dismissed by the defendant from his employment for gross misconduct via Exhibit I, which is dated 21st day of January 2015. I find that the dismissal letter is signed by Gbenga Ogunleye and co-signed by Mr. Enobon Egere, both of the Industrial Relations and Work Ethics Department of the Defense. As a meaning of suspension, it has been held that suspension means to defer, lay aside, hold in abeyance, but does not mean to bring to an end. It means temporary removal from office.
I would have been done.
Yeah, cases of Akinyanju against Unilorin and the case of Jimo against Olawoye. The settled position of the law that the court is bound to decide the case of parties based on the evidence laid before it. The claimant has alleged that suspension was not properly done by the claimant because, no, by the defendant. This should be defendant. Defendant. Claimant has alleged that the suspension was not properly done by the defendant because it was done orally. He has not led any evidence as to what the proper mode of his suspension should be. The court cannot speculate. What is important in this case, as far as the court is concerned, is the fact that the suspension of the claimant was communicated to him by his supervisor on behalf of the defendant. The purpose of the suspension was to allow the defendant conduct investigation into the allegation of forgery of statement of account levied against him by the defendant, pursuant to the letter written to it by the French embassy to confirm the authenticity of the statement of account submitted by the claimant to French embassy to process his Schengen visa. There's no doubt that the position of law is that an employer can properly suspend an employee for the purpose of investigating an allegation of misconduct against him. And so what constitutes gross misconduct has been defined as a conduct of grave and weighty character, such as to undermine the confidence which should exist between the employee and the employer. It has also been defined to mean what the employer makes it to be, such as some conducts considered to be detrimental to the corporate existence of the organization. Where an employee is found guilty of misconduct, he can be dismissed summarily without notice or wages. See the case of Borishadi against NBN Limited and the case of UBN PLC against Suarez. Their citations are supplied. From Exhibit C, it stated thereon that claimant was dismissed from his employment on the ground of misconduct. Since claimant has not led evidence as to his proper mode of suspension, I know that he was properly suspended by the defendant, and issue 1 is accordingly resolved in favor of the defendant against the claimant. Issue 2, that's whether the claimant has proved that he was maliciously prosecuted by the defendant. The ingredients of the thought of malicious prosecution, which must be proved by the claimant in this case, are as follows. 1, that the claimant was prosecuted by the defendant on a criminal charge, that is, the law was set in motion against the claimant by the defendant. 2, that the criminal prosecution was decided in favor of the claimant. 3, that the prosecution was without reasonable or probable cause. And 4, that the prosecution was malicious or done out of malice. It has been held that the claimant bears the honor to establish all the aforementioned ingredients which are conjunctive. Say the cases of Balogun against Amibikang, Efium against Ayomba, Ebenige against Archie, Ojo against Okitipa Oil Palm PLC. The citations are supplied. In order to prove malice, the claimant must prove that the defendant was bent to embarrass him at all costs and ensure that he is incarcerated for the offense or made to pay a fine for the offense for which he had no actus reus or mens rea or both. There must be an unequivocal mind or conduct on the part of the defendant to destroy the claimant who is innocent. See the case of Ojo and Okitipa Oil Supra. It has been held that The fact that a person merely reported a matter to the police without more cannot grant the action for malicious damage. From the facts before this court, it's true that defendants wrote Exhibit H to the Divisional Police Officer Adigbe, Abeokuta, Ogun State, to investigate the allegation of forgery of the claimant's statement of account. For the purpose of clarity, the content of the defendant's letter is reproduced as follows. After the address, 5th day of December 2014, Divisional Police Officer Adigbe, Abeokuta, Ogun State. I then copy the Commissioner of Police, Ogun State Command, Elewe Road, Abeokuta, Ogun State. There, sir, forgery of account statement of our staff, Adegboye Akim, account number 100-984-6554, by Daniel Dutton and Akim Adegboye. Following the account statement verification received from the French consulate to confirm account statement submitted by Adegboye, for the purpose of securing Schengen visa, we have confirmed that the statement was forged and not a true replica of the account on our system. Please find attached copy of the fake statement. Our staff, Adegboye Akim, has alleged that the forged statement of account was produced by an agent whose name is Daniel Dutton, whom we have handed over to your division. Can I use your good office to apprehend and prosecute all the people connected to this fraudulent act? Please be informed that UBA PLC provided this information to you without prejudice. End of quote. For the foregoing wordings of the letter, there's no doubt that the defendant merely reported the commission of a crime to the police, which they are mandated by law to do. It's obvious from paragraphs 3 and 4 of the letter, the defendant has not targeted the claimant for prosecution. Also, the case was investigated by the police, who later arraigned the claimant for forgery of his account statement. From the evidence before this court, the prosecution of the claimant was initiated and done by the police in the magistrate court after they must have been satisfied that a prima facie case of forgery was made against the claimant. I hold that there is no evidence before this court upon which it can hold that the claimant was prosecuted by the defendant on the criminal charge or set the law in motion against him by the defendant. I hold that claimant was rightly prosecuted by the police, who set the law in motion against him. It's of no moment that 2 employees of the defendant testified in the court during the trial of the magistrate, court, as it is the prerogative of the police to call witnesses or even force unwilling witnesses to testify in any criminal case. In respect of the second ingredient of the tort, which is that criminal prosecution must have ended in favor of the claimant, there's no doubt that the claimant was discharged of the offense of forgery by the magistrate who heard the case per Exhibit C. It's a known fact that standard of proof in criminal matter is that of beyond reasonable doubt. Regarding the third ingredient as to whether the claimant's prosecution was without a reasonable cause, I hold that the prosecution of the claimant by the police in the magistrate court in Abeokuta, Ogun State was born out of a reasonable cause, as it was based on the letter written to the defendant by the French embassy to confirm the statement of account tendered by the claimant to obtain visa from them, and the defendant found that the statement of account was forged. As to whether the prosecution of the claimant at the magistrate court was malicious or done out of malice, for the totality of the evidence before this court, I hold that the claimant has not established any malice against the defendant. I also hold that the defendant acted in good faith by reporting a crime to the police for investigation. I hold further that the defendant has taken the step taken by it in order to preserve the integrity of his business. In conclusion, I hold that the claimant has not established malicious prosecution against the defendant. Issue 2 is hereby resolved in favor of the defendant against the claimant. Instead of issue 3, further from the evidence led before this court, you can really hold that claimant's account was blocked by the defendant. The defendant has led evidence. The claimant has led evidence that after his suspension, the defendant blocked his account domiciled with it with account number 100-984-655, and that after the criminal case was decided in his favor, the defendant still refused to unblock the account. The defendant has denied that he blocked claimant's account as alleged by him, and has gone further to tender Exhibit J in support of the pleading to show that claimant made withdrawals from his account at the relevant period. From the findings of this court, the evidence that led to the dismissal of the claimant by the defendant started around 5th of December 2014 to about 21st day of January 2015. One letter of dismissal, Exhibit I, was issued to the claimant. As well stated by the claimant, as well stated by this defendant, stated by defendant, there were several withdrawals and transactions made on the account by the claimant from 9th December 2014 to 24th December 2018, which was the last date of the submission of account. Claimant clearly bears the onus to establish his claim before this court on the balance of probabilities based on the preponderance of evidence, which the claimant has not done in this case. I hope that the claimant has not established before this court that his account was blocked, and his prayers in that regard hereby refused. This claimant may release before this court appeal. Other release is data there to have also failed, and I so hold. Alternative release. The alternative release of the claimant have also failed since their success depends on the success of the main release, which are failed. I also hold. In conclusion, I hold that claimant's case has failed in its entirety, and the same is accordingly dismissed. I make no order as to court. A judgment is entered accordingly.
Hello, my lord.
Yes, please.
We are indeed very grateful for the well-considered judgment. We have nothing to offer the court but to continue praying for your lordship. We seek God's protection and guidance for your lordship.
Amen.
We are very grateful.
Yes.
We are most grateful for the well-considered judgments. We pray that the Almighty God will continue to increase the wisdom of my Lord. We are grateful to the court.
Thank you. I'm going to call the case of Judge Olu. Judge Olu and Pacesetter Transport Services. Where's Judge Olu? Judge Olu. Yes, Judge Olu and Pacesetter Transport Services Limited. Pacesetter Transport Services.
Yes,
Sorry?
Claimant is in court, my lord. Defendants are absent.
The claimant is present. And the defendant is absent?
Defendants are absent.
Okay, claimant present. Defendant
absent.
Absent. Yes, appearance, please.
Yeah.
Appearance.
May it please the court. Olubayo Oyedeji is my name. May it please the court, sir. Olubayo Oyedeji for the claimant, sir.
Yes.
Olubayo Oyedeji for the claimant, sir.
Yeah, yes, I've heard you, Council. I've heard you.
I'm grateful. Yes, sir.
You're welcome. Yes,
thank you, sir.
Appearance for the defendant.
I'm not sure
that there's no legal representation for the defendant.
As the court pleases, sir.
Okay, no legal representation for the defendant. So, I'm going to say judgment taken by me. Yes, this is judgment of the court. So it's a 35-page judgment. So as usual, I've started judgment by making reference to the claims before the court as contained in the claimants originating processes. I've summarized the brief facts of the case as presented by the defendant, and then I've summarized submissions in the joint written address of the defendant. Summarize all that. The submissions. The submissions, even claimant's written address, the submissions therein. Submissions therein. Summarized. And that takes me to page 21 of the judgment, which is the court's decision. And so now, upon going through the claims before this court and the response of the defendant there to include the notice of the plenary objection of the defendant, this court of the view that the issues for determination are as follows. Whether in the circumstance of this case, the plenary objection raised by the defendant can be sustained. 2, whether the first defendant followed the conditions of the employment between it and the claimant, while it purposely retired the claimant from his employment. But the first defendant. 3, whether the claimant is entitled to the other relief sought by him in this case. Issue 1, that is, whether in the circumstance of this case, the objection raised by the defendant can be sustained. The grounds for defendant's plenary objection is that the first defendant's name as it appeared on the executive process is not the corporate name of the first defendant as stated on the certificate of incorporation. The second and third defendants are not necessary parties to this case. That this suit is grossly incompetent and should be struck out. Defendant's objection has 2 legs. The first leg is that the defendant is sued the wrong name. And the other is that second and third defendants are not necessary parties to this case. And the written address in support of the plenary objection, defendant formulated a sole issue to which whether or not the claimant applicant's action were able to be struck out for being competent in the circumstance. The summary of the defendant's submission is that for a court to have jurisdiction to hear a matter, following conditions must be present, to which the court must be properly consulted regarding the number and the qualification of the members of the bench, and no member must be disqualified for one reason or another. Subject matter of the case must fall within the jurisdiction of the court, and there must be no feature in the case which prevents the court from exercising its jurisdiction, and the case must be initiated by due process of the law and upon fulfillment of any condition precedent to the exercise of jurisdiction. Defendants relied on the case of Opeloye against Ikemdele. Petition is supplied. Defendants submitted that in this case, failure of the defendant to sue the first defendant, his proper name, is the feature in this case which is capable of preventing this court from exercising his jurisdiction to hear this case. Defendants also defined proper parties as those who are directly involved in the cause of action, which are the claimant who has suffered some damages, and the defendant whose act or omission has occasioned damage. The case relied on they relied on the case of Mobi Producing Nigeria Unlimited against ASABA and others. Defendant further submitted that the name of the first defendant as it appeared on the list of summons, and other processes is not the name of the first defendant as it appears on the certificate of incorporation, and that this raises doubt as to the identity of the person sued, which is capable of officiating the entire proceedings, and that this ground is enough to warrant the striking out of this suit. Further submitted that an action must contain at least two parties, claimant and the defendant, that an action will be meaningless if it does not contain the names of the appropriate parties. Submitted that it's not necessary to join the second and third defendant since they took instructions for the first defendant, that they were not that where the court finds that the name of the first defendant as they appeared on the complaint is not the same as it appears on the certificate of incorporation, should be struck out for being incompetent. So that takes me to the submission of the claimant in respect of the plenary objection. So, claimant submitted, in response to defendant's submission, claimant submitted that the standard in evidence is letter of appointment dated 5th day of February 2014, letter of confirmation dated 30th day of August 2014, the staff identification card among other exhibits to prove his employment with the first defendant, that all the exhibits tendered by the parties range from exhibit A to L. There are several other correspondences exchanged with the claimant solicitor bear eloquent testimony to the fact that the first defendant holds itself out as pace setter transport services, though the court to so hold. Claimant further submitted that it is strict law that where parties have embodied the terms of their contract in a written document, extraneous evidence is not required to add, subtract from, vary, or contradict the terms of the written document. He relied on the case of Solicitor General, Western Nigeria, versus Dr. Festus O. Adebonojo and others. In the case of Olatunde and OAU and another, so citations of the cases are supplied. Submitted at the beginning of the contractual relationship between the claimant and defendant, the first official document that celebrated their industrial matrimony, the letter of appointment issued to the claimant by the defendant. The claimant was interviewed and his birth data taken, and he did not hide his age or manipulate his date of birth, but supplied everything to the defendant during the interview, that it is the prerogative of the defendant to issue a letter of appointment to the claimant, which was believed would be constructed on the authentic letterhead of the company, except the first defendant is set up for some fraudulent purpose other than what it holds itself out to be. The appointment letter issued on 25th February 2014 was the first official document exchanged with the claimant. The document has not been withdrawn from the claimant or replaced or invalidated by the defendant for any reason. The claimant cited the case of Mr. P.T. Adedeji against Dr. Moses Obajimi. Citation is supplied. We submitted further that parties are bound by terms of the contract they willingly entered into. The law will not allow a party who contracted willingly with another to breach the contract and then turn around to claim benefits under the same contract. And in an action for unlawful dismissal or termination of appointment, the starting point would be the conditions of service, and the plaintiff must plead the date of appointment. So reliance is based on the case of FMC Idoeki against Olajide. Citation is supplied. Claimant submitted that the court does not engage itself in an act of writing and rewriting agreements for parties. That where the words in an agreement are clear, precise, and unambiguous, as in this case, the court shall, without much ado, expand those words, their ordinary natural sense, in order to give a true and genuine effect to the intention of the party. Like the case of Williams against Williams and Jade Simi against Egbe. And so their citations are supplied. Claimant submitted that he has not only shown the court through empirical evidence by way of exhibits, but have proved to the court that at the hearing that he was employed by the first defendant or the second and third defendant acting as the first defendant's agent, not the court to so hold in his favor. Now, I've gone through the evidence before the court. Usually, exhibit A, that is the claimant's letter of employment. Exhibit D, letter of confirmation for appointment of the claimant. And exhibit E, letter written by the first defendant to the claimant to show that some of the bosses have been granted, amongst other documents, which were printed on the first defendant's letter head paper. I find that the first defendant has stated his name to pay certain transport services. Even in exhibit C, which is claimant's identity card while he was in the employment of the first defendant, the name of first defendant stated as pay certain service for your state government. It's not an issue that the first defendant entered into the contract of employment with the claimant with this name. The name that the first defendant was bearing earlier, as shown by exhibit B, is Transport Company Limited. Somebody is disrupting the proceedings of the court there. Please, gentlemen. So as well as submitted by the claimant, there was no time the first defendant withdrew these letters or informed the claimant that it was bearing any new name. Now, is it an issue that claimant was employed by the first defendant? If the first defendant is now saying that he was bearing another name other than the name on the letterhead by which is communicated to the claimant, his employment, confirmation, and gave him other information, and that the name on his letter is incorrect, I agree with the submission of the claimant that this must be for a fraudulent purpose and that this is done in bad faith. Portion of the law is that a party will not be allowed to benefit from its misrepresentation or wrong so as to deny the other party of their benefit under a contract. See the case of Oceanic Bank International PLC against Broken Agro Allied Industrial Limited. AP Limited against Owoduni. The associations are supplied, and see also this. See also section 169 of the Evidence Act 2011 as amended. In AP versus Owoduni Supra, the Apex Court held that the law will not allow any person to reap any benefit from his sole wrongful act. To allow such is manifestly unjust, and we portray the law as an instrument of injustice. End of quote. I hope that since the first defendant has, by its act, caused the claimant to believe that his name is Peseta Transport Services, he shall not be allowed to deny the truth of such fact. Also, as submitted by the claimant, it's not an issue that the first defendant is the employer of the claimant. For aforementioned reasons, I hold that first defendant is properly sued as Space Center Transport Service. As to whether second and third defendants are properly joined as parties to this suit, that the Nigerian law parties have been classified as proper parties, necessary parties, and desirable parties, which have been defined as follows. Proper parties are those who are joined as parties for some good reasons, though they are not interested in the case. Desirable parties are those who have interest in the particular case or who may be affected by the result or outcome of the case. And necessary parties are those who are interested in the subject matter of dispute, but in their absence, the case cannot be fairly determined. So I've learned the case of against Lalong, this of MBA against Kehinde, against Owa Orua, against PDP and others. The citations are supplied. Claimant has averred in his statement of fact, also led evidence in his written statement or note before this court of the position occupied by the second and third defendants in the employment of the first defendant. See, for instance, paragraph 5 to 9 of the claimant's statement of fact. I wish to state that in any case before this court, the claimant is allowed to join anyone who has played any role whatsoever in the activities that led to the matter, or who will be affected one way or another as a party to the case. This will serve the purpose of fair hearing and interest of justice. This is the position stated in Order 13, Rule 4 of the rules of this court, which provides, and I quote, a person may be joined as a defendant against whom the right to any relief is alleged to exist, whether jointly, severally, or in the alternative. End of quote. Also, Order 13, Rules 6, 7, 8, and 9 of the NICN Rules 2017. I therefore hold that in the circumstance of this case, second and third defendants are properly joined as parties to this case that have played some roles in the activities alleged to this case. I hold further that the plenary objection of the defendant or the first defendant is raised in bad faith to deny the claimant of benefit under this contract. It's accordingly dismissed. Issue 1 is resolved in favor of the claimant. So that takes me to issue 2, whether the first defendant followed the conditions of employment between it and the claimant, why it completely retired the claimant from the employment with the first defendant. So the position of the law is that contract of employment is the bedrock of any employment relationship, and parties are bound by the terms of the contract which they willingly entered into. It's not an issue that the employment relationship between the claimant and the first defendant, in this case, that of master and servant employment relationship. The law is also settled that for termination of any employment relationship to be valid, must be done according to the terms of employment contract. Otherwise, termination will be declared as wrongful, and the employee will be entitled to damages. Claimant has led evidence that the first name which defendant operated under is Trans-City Transport Company Limited. This fact is not an issue, as the first defendant has admitted this fact in paragraph 5 of his statement of defense and other process, and the evidence is led before this court. I find that from the evidence before this court that the condition of employment in this case are stated in Exhibit A, B, and D. Exhibit A, letter of appointment dated 25th day of February 2014, contains the conditions, the claimant's basic salary, which is stated as grade level 7, step 1, in the sum of 169,711.48 per annum, with effect from 6th day of March 2014. Probation period for at least 6 months, from 25th day of January 2014. Termination of employment without notice during the period. Annual leave for 21 days. 10% of the annual basic salary as leave bonus. 5,653 naira 71 kobo as housing allowance, 2,281 naira 63 kobo as transport allowance. Claimant's employment was confirmed via Exhibit B, which restated his basic salary and the salary grade level stated above. In Exhibit B, first defendant reversed condition of service at page 10, section 2.6. Provision is made for resignation and termination of employment. In section 2.2b and c, it is stated as follows. Quote, an employee may leave the service of the company by giving notice in writing through his departmental head as follows. Junior staff, 1 month notice of payment in payment of a month's salary in lieu of notice. Management and senior staff, 3 months notice of payment of 3 months salary in lieu of notice. Under C, similarly, a company may determine the appointment of an employee by giving the employee such notice in writing, and the employee would have given under paragraph B. This condition of service or paying such salary in lieu of notice, and the employee would have paid under section. Further submitted that the employment relationship of the claimant and the first vendor is that of a purely master-servant relationship, which is being regulated by the terms and conditions stated in the revised conditions of service of the first defendant. As can be seen from section 2.2b and c, it was compulsory for the first vendor to give claimant notice of 1 month for his employment to be validly terminated. And owing to the personal nature of the employment relationship generally, notice must be addressed personally to the employee. That is the claimant in this. It's evident that sometimes in the month of November 9, 2019, defendant issued a circular which is based on its notice board, where it listed the name of the claimant as one of the staff members whose employment has been terminated, and the claimant's salary was immediately stopped by the first defendant. Claimant demanded for the reasons for the action of the first defendant, but the reasons stated were not clear to him. However, after claimant's counsel wrote a letter of demand, the first defendant, it replied via Exhibit A that claimant was granted indefinite leave since some of the bosses of the first defendant were grounded. I found and hold that the notice allegedly given to the claimant by the first defendant did not accord with the terms of the employment between the parties. I therefore hold that this is a clear violation of the conditions of employment between the claimant and the first defendant. Further submission that the claimant's appointment was terminated on ground of age does not justify their failure or refusal to give the claimant the requisite notice clearly stated on the condition of employment. Also, I do not agree with the submission of the first defendant that claimant was properly notified of his retirement and that he was properly retired for the reason stated above. I therefore hold that the first defendant did not follow the conditions of employment between it and the claimant when it compulsory retired the claimant from his employment with the defendant. Issue 2 is accordingly resolved in favor of the claimant. This takes me to issue 3. Whether claimant is entitled to the other relief sought by him in this case. So I've stated the reliefs. Reliefs from A to I. In respect of the first relief, it's not an issue that the Trans-State Transport Company Limited revised condition of service is appropriate staff handbook applicable to the employment of the claimant. And the first defendant as this fact has been admitted by the first defendant and as so forth. In respect of relief 2 of the claimant, I said that the relief 2 of the claimant has been taken over by the holding of this court that the first defendant has not terminated the employment of the claimant in accordance with the terms and conditions of the employment between the claimant and the first defendant. Since the first defendant did not properly give him the notice as stipulated in the condition of employment, that is Exhibit B. However, this court is not able to hold that the termination of claimant's employment is illegal, null and void, since claimant's employment is not with statutory flavor, and as such, another can only be made in a contract of employment with statutory flavor. From the evidence before this court, the conditions of the employment between the parties are stated in the letter of employment, confirmation, and first defendant's revised condition of service, that's SCBP. There's no evidence that defendant's employment is with statutory flavor, additionally with the submissions of the defendant that the employment relationship between the claimant and first defendant is that of a purely master and servant relationship, which is being regulated by the terms and conditions stated in the revised condition of service of the first defendant. For the reason earlier stated, this court cannot hold that claimant's employment as driver with the first defendant still subsists, nor can the court restate the claimant to his employment. Rather, this court hereby holds that claimant's employment with the first defendant, though wrongly terminated, remains terminated, and the claimant can only be compensated in damages for wrongful termination. Salaries and allowances. In respect of claimants' prayers for salaries, benefits, and allowances provided in Exhibit B as follows. Section 1.4 on retirement benefits. 1.4.1a, we talk about compulsory retirement. Provides that all employees must voluntarily retire from the service of the company at the age of 60, and benefits will be paid in accordance with the approved gratuity and pension scheme as in Appendix 2. II. The voluntary retirement age is 45 years and above. III. An employee retiring at 60 will qualify for retirement benefits, provided that he has served the company continuously for 10 years. In the case of voluntary retirement, at 45, a minimum of 15 continuous years must have been put in to qualify for benefits. I agree with the submission of the defendant that from above provisions of the revised condition of service of the first defendant, since the claimant was employed by the letter of appointment dated 4th day of December 2015, and evidence had been laid that claimant was about 60 years, the first defendant in 2019, and this part has been admitted by the defendant. It means that by the claimant rather. It means that the claimant only worked for the first defendant for a little above 4 years, and that he's as such not entitled to retirement benefits and allowances that people who are compulsory retired are entitled to, because he did not work for 10 years straight in the first defendant as provided for in section 1.4a III of the revised condition of service for the first defendant. I so hold. Salaries submitted by the claimant that is submitted by the claimant that he has made out his case and pleaded his monthly salary, the sum of 30,000 naira per month, which have been denied him since November 2019. Reference is made to Exhibit D, the defendant's revised condition of service, which states in section 2.23, which states in section 2.23a, under wages and salaries does. Quote, an annual salary increase shall be as per salary structure, shall be granted to the employees at the anniversary of the employee's appointment / promotion, subject to availability. In section 2.24 of the same exhibit, claimant, it says that claimant is entitled to fringe benefits as follows. And in section 2.24.1, it has listed numbers of fringe benefits with the vendor's employees are entitled to include housing allowance, transport allowance, leave bonus, exigency allowance, accommodation loan, and launch subsidy. Section 2.28 on leave matters, and specifically section 2.28.1 says the number of days of the which the claimant is entitled to as the staff of the first defendant. Item F specifically states that all earned leave must be taken within the year in which they fall. Item G in particular says that leave allowance shall be paid at the eve of the leave. The claimant has reproduced the above provision of the first defendant provision of service as it relates to the entitlement of the claimant, but he has not calculated the amount that is actually due to him under the section, nor has he specifically claimed any amount from the first defendant under the section. The second position of the law is that a party bears the onus to place credible evidence before the court to establish his claim before the court, and that the court cannot judge based on speculation. Claimant not having established these heads of claim, thereby the claims are hereby refused by this court. I so hold. It's not enough that he has established the amount of the salary to be 30,000 in pleadings and evidence during the exhibit help, and that to do more than this by showing how much is entitled to. Section 2.31 of the end of the year bonus, on the end of the year bonus states plus end of the year bonus of a minimum of 50%, a maximum of 100% of monthly basic salary will be paid to the employees of the company in December of each year. On the issue of end of the year bonus, claimant has had it to calculate how much is legally entitled to be paid by the first defendant. The evidence that he was not paid while some other employees of the defendant were paid. How that this court cannot grant this relief for want of evidence. And that takes to gratuity. On the issue of gratuity, is submitted that the claimant's employment took effect from 25th day of February 2014, which could have earned the claimant gratuity in line with the computation in Exhibit D under Appendix B of the defendant's revised condition of service. Instead of gratuity, it is provided in section 1.1.3.1 of the defendant's revised condition of service as follows. Quote, gratuity will be paid to any employee who leaves the services of the company, provided his appointment has not been terminated or he has not committed any act of misconduct that would have led to termination, disappointment, or dismissal. A year's gross salary will be paid. To qualify for gratuity, an employee must have served the company for a period of not less than 5 continuous years. So this end of quote. It's obvious that claimant has not satisfied all of the above conditions so as to be entitled to gratuity, because contrary to the conditions stated above, claimant was employed by the first defendant on the 25th day of February 2014, and his employment was allegedly terminated on 9th November 2019. Claimant has worked for 4 years and 8 months, which can be approximated to 5 years, thereby satisfying above conditions in part. However, since the above conditions are conjunctive and the claimant must satisfy all the conditions to be entitled to gratuity, a claimant has not met with all the conditions, I hope that claimant is not entitled to gratuity. That claim for pension. The claimant, the first defendant averred in his joint statement of defense dated 16th day of June 2021 that he did not only write the pension instead to pay the claimant his gratuity and benefit under the pension scheme. It also remitted the money standing to the credit of the claimant as gratuity and pension to the pension manager. That has been admitted by the claimant through examination in this case that he has been duly paid his entitlement that is entitled to. It's entitlement that he's entitled to by the Leadway Pension Limited as of today. The claimant has admitted that he has been paid his pension under cross-examination. I hold that this relief has been overtaken by events. And that takes me to damages. Claimants submitted that the malicious act of stopping salary and employment by the first defendant was a fundamental breach of the employment contract between the parties, and as such, the claimant is entitled to compensatory damage. My finding is that claimant's salary was stopped after his employment was terminated by the first defendant. However, since the court has earlier heard that claimant's employment was wrongly terminated by the first defendant and that he is thereby entitled to damages, sum of 500,000 naira awarded in favor of the claimant against the defendant, against the first defendant as damage. Also, since cost follows defense, cost of 500,000 awarded in favor of the claimant. The entire judgment sum should be paid within 30 days of the delivery of this judgment. Alternative claims of 5 million as aggravated damage. Since the court has earlier awarded general damages in favor of the claimant, this claim for aggravated damages is hereby refused, as this will amount to compensation. In conclusion, court hereby holds as follows. The plenary objection of the defendant is hereby dismissed. That the first defendant has not terminated claimant's employment in accordance with the conditions of employment between the parties, thereby rendering the termination as wrong. 3. A sum of 500,000 naira is awarded in favor of the claimant against the first defendant as general damages for wrongful termination. 4. Claimant's prayers for arrears of salaries, allowances, gratuity, aggravated damages, and restatements hereby refused. 5. Cost of 500,000 is awarded in favor of the claimant against the first defendant. And judgments should be paid to the claimant by the first defendant within 30 days the delivery of this judgment. A judgment is entered accordingly.
For the word considered judgment, sir. May God continue to bless the soul and the heart of my Lord. My Lord, we are very grateful. Thank you, sir.
You are welcome.
Yes, sir.
My Lord. My Lord.
Yes, please.
My Lord.
Yes.
Yes, my Lord. I want to
Yes, because I cannot hear. I can't hear what you say. You ought not be smart today. We are not speaking of them.
Yes, of course. Yes, and damage.
So, where is the file for this? So the next case is where's the next case is somebody was talking. I couldn't hear what the person was saying. No. So the next case is also the case of
I want to seek the indulgence of
Pastor, your voice, I can't hear what you're saying very well. Maybe when the network is okay, maybe you can call the because I can't hear what you're saying. So the next case for consideration is the case of Owolabi Jimoh Ajagbe and Pacesetter Transport Services and 2 others.
My Lord, claimant is present, sir.
Person is second. Try to check something. So I think that the defendants are absent.
Yes, sir. Claimant is present. Defendants are absent.
Yes, appearance, please.
Hello, with the greatest respect, sir. Olubayo Oyedeji, I appear for the claimant, sir. I'm most grateful.
You're welcome. Yes, please. Should I tell that there's no appearance for the defendant?
My Lord, that's called, please, sir. They're not online.
Hello.
They're not here.
Yes, sir.
Yes. He's saying hello then.
Hey. Oh, God.
No, that's not that.
I'll try my best.
Yeah, so this case is a sister case to the other one.
That's the places.
And there isn't much difference between the two. The 34 page judgment. So, and question is, as usual, I summarized the claim. I made reference to the claim before the court. And then I summarized the submissions and the final written addresses of the parties. So let's take me to page 20 of the judgment, which is the of judgment, which is the court's decision. So that as we're going through the claims before the court, I formulated 3 issues. The first one, whether in circumstances of this case, no objection raised by the defendant can be sustained. Also, issue 2, whether first defendant followed the position of the employment between it and the claimant, why it compulsory retired the claimant from his employment for the defendant. And the third one is whether the claimant is entitled to the other relief sought by him in this case. So, and in respect of the first issue, I said that the grounds for defendant's objection is that first defendant's name as it appeared on the unit process is not the corporate name of the first defendant as stated on the certificate of incorporation, and that the second and third defendants are not necessary parties to this case, that this suit is broadly incompetent and should be struck out. Defendant's objection has 2 legs. The first leg is that the first defendant is sued in a wrong name. Another one is that second and third defendants are not necessary parties to this case. In the written address in support of the objection, I've summarized the submission of just made by the first defendant in support of the plenary objection. Also, I've also summarized the submission made by the claimant against the plenary objection. And I've now said that to my station, as I've gone through the evidence before this court. Especially Exhibit A, the claimant's letter of employment, Exhibit H, letter written by the first defendant to the claimant to show that some of the processes have been granted, amongst other documents which were printed on the first defendant's letterheaded paper And in them, first defendant has stated his name as the pay setter transport service. Even as the SBC, which is the claimant's identity card, while he was in the employment of the first defendant, the name of first defendant is stated as pay setter transport service. It's not an issue that the first defendant entered into the contract for employment with the claimant in this case. The name that the first defendant was bearing earlier, as shown by Exhibit B, is Trans-City Transport Company Limited. As already submitted by the claimant, there was no time the first defendant would do these letters or inform the claimant that was bearing any name. Nor is it an issue that claimant was employed by the first defendant. If the first defendant is now saying that it was bearing another name, other than the name on the letterhead, by which it communicated the claimant's employment and gave him other information. Not saying that the name is not correct, I will agree with the assumption of the claimant that this must be for a fraudulent purpose and that this is done in bad faith. Position of the law is that a party will not be allowed to benefit from his representation or wrong so as to deny the other party of their benefit under a contract. So the case of Oceanic Bank International PLC against Broken Agro Allied Industries Limited, and then the case of AP Limited against Owoduni. Also, that in the case of AP and Owoduni Sopra, the first court has held that, quote, the law will not allow any person to reap any benefit from his own wrongful act. To allow such is manifestly unjust and will portray the law as an instrument of injustice. End of quote. I hope that since the first defendant has by its act caused the claimant to believe that his name is Space Setter Transport Service, he shall not be allowed to deny the truth of such fact. Also, as submitted by the claimant, it is not an issue that first defendant is the employer of the claimant. For the aforementioned reason, I hope that the first defendant properly sued as Space Setter Services, total services. And so whether second or third defendant properly joined as parties to this suit, under the Nigerian law, parties have been classified as proper parties, necessary parties, and desirable parties, which have been defined as follows. Proper parties are those who are joined as parties for some good reasons, so they are not interested in the case. Desirable parties are those who have interest in the particular case, or who may be affected by the sort of or outcome of the case. Necessary parties are those who are interested in subject matter of the suit, but in their absence, but in their absence, the case cannot be fairly determined. I've relied on some cases that appear along against Lalong and MBA against Kehinde and Owa, Bolu and others against PDP and others. Claimant has averred in his statement of facts and also led evidence in his written statement on note before this court on the position occupied by the second and third defendant in the office of the first defendant and the roles played by them in the event that led to this case. In any case, before this court, the claimant is allowed to join anyone who has played any role whatsoever in the activity that led to the matter and will be affected one way or another as a party to the case. This will serve the purpose of fair hearing and interest of justice and prevent multiplicity of action. This is the position stated in Order 13, Rule 4 of the rules of this court, which provides that the person will be joined as defendant against whom the right to any relief is alleged to exist, whether jointly, severally, or in the alternative. Also, Order 13, Rule 6 to 9 of the rules of this court. I therefore hold that the circumstance of this case, the second and third defendants are fully joined as parties to this case. I hope further that the clear objection of the first defendant is raised in bad faith that the claimant of the benefits under this contract are currently dismissed, and issue 1 is resolved in favor of the claimant. In the sort of issue 2 as to whether first defendant follow the conditions of the employment between it and the claimant, why it compulsory retire the claimant from its employment. That should be its employment, from its employment with the defendant. Okay, it's employment with the defendant. The second position of the law is that the contract of employment is the bedrock of any employment relationship, and that parties are bound by the terms of the contract which they willingly entered into. It's not an issue that the employment relationship between the claimant and the first defendant, in this case, is that of master-servant relationship. The law is also settled that the termination of the employment relationship to be valid. That for the termination of employment relationship to be valid, it must be done in accordance with the terms of the employment. Otherwise, the employment will be declared as wrong and the employee will be entitled to damage. Claimant has led evidence that the first name which the first defendant operated under is Trans-City Transport Limited. This fact is not an issue, as the first defendant, in paragraph 5 of statement of defense, other processes has admitted this fact. I find that from the evidence led before this court, that the conditions of employment in this case are stated in Exhibit A and B. Exhibit A, letter of appointment dated 11 June 2013, contains the conditions as to the basic salary, probation period, annual leave, other conditions, housing, personal allowance. Gross employment was confirmed via Exhibit D, which stated his basic salary and the salary grade as stated above. From Exhibit A, claimant joined the employment of the first defendant on 11th day of June 2013, and properly terminated in November 2019. In Exhibit B, first defendant's reverse condition of service at page 10, section 2.6, provision is made for resignation and termination of employment. In section 2.2b and c, stated as follows: an employee may leave the service of the claimant by giving notice in writing through his department head as follows: for junior staff, 1 month notice or payment of a month's salary in lieu of notice. Management and senior staff, 3 months notice or payment of 3 months salary in lieu of notice. Similarly, the company may determine the appointment of an employee by giving the employee such notice in writing as the employee would have given under paragraph B of this condition of service, or paying such salary in lieu of notice as the employee would have paid under the section. End of quote. So that's submitted that the employment relationship of the defendant and the first of the claimant and the first defendant, that of purely master servant relation, which is being regulated by the terms and conditions stated in the revised condition of service of the first defendant. I usually with the submission, as this is obvious from the first protocol. As can be seen from section 2.2b and c, or it was compulsory for the first defendant to give the claimant notice of 1 month for his employment to be validly terminated. Whenever gave the claimant any such notice, and there's no evidence that the claimant was given any personal notice, instead of giving the claimant requisite notice, first defendant only gave evidence that claimant's name was amongst the names of the employees whose names were pasted on his notice board as having been compulsorily retired. I hope that this is a clear violation of the conditions of employment between the claimant and the first defendant. Defendant submitted that based on above provision of the revised condition of service of the first defendant, the age of the claimant as at 2019 which was above 60 years. Claimant was lawfully retired in accordance with the revised condition of service of the Oyo State Sector Company Limited. The claimant's name was fully written among those completely retired by the first defendant, having stayed beyond 60 years, which is the year for compulsory retirement, and the first defendant. I do not agree with the submission of the first defendant that claimant was properly notified of retirement, or that he was properly retired. For the reasons stated above, in any case, there's evidence before this court that claimant was born on the 12th of April 1948 and employed by the defendant on the 10th day of June 2013 at about 65 years of age. It's shocking to me that first defendant has insisted that the retirement age of the claimant is 60 years when he was employed by the first defendant when he was above 65 years. Though defendants have argued that out of sheer benevolence, first defendant was paid claimant's defendant paid claimant's salary for the month of November 2019 and 2,000 for December, which some claimant has stated is for Christmas rights. First defendant has not said that the money paid to the claimant is salary in lieu of notice. I therefore hold that the first defendant did not follow the conditions of employment between it and the claimant, while it completely retired the claimant from his employment with the defendant, thereby rendering the termination wrong and entitling the claimant to be compensated in damage. Issue 2 is accordingly resolved in favor of the claimant. Because of issue 3, whether the claimant is entitled to the relief sought by him in this case. So I've reproduced the reliefs sought by the claimant herein. I said that in respect of the first relief, it's not an issue that the Trans City Transport Company Limited reverse condition of service with the appropriate staff handbook applicable to the employment of the claimant and the first defendant, as this fact has been admitted by the first defendant as so hold. This is our relief 2. I said that the relief 2 of the claimant has been taken care of and the holding of the court that the first defendant has not terminated the employment of the claimant in accordance with the terms and conditions of the employment between the claimant and the first defendant. Since the first defendant did not give him notice as stipulated in the condition of employment, Exhibit B. However, this court is not able to hold that the termination of the claimant's employment is illegal, null and void, since claimant's employment is not with statutory claim. From the evidence before this court, the condition of employment between the parties considered in the letter of employment and the first defendant's reverse condition of service, Exhibit B. There is no evidence that claimant's employment is with statutory labor. I agree totally with the submissions of the defendant that the employment relationship between the claimant and the first defendant is a purely master-servant relationship. It is regulated by the terms and conditions stated, the reverse condition of service, and the letter of appointment. For the reason earlier stated, this court cannot hold the claimant's employment as driver with the first defendant's state of state, nor can the court restate the claimant with employment. Rather, this court hereby holds that claimant's employment with the defendant, though wrongly terminated, remains terminated, and the claimants can only be compensated damages for wrongful termination. Salary or benefits. I'll refer to the three sections of the Exhibit B, section 1.4. And the claimant was employed by the letter of appointment dated 11th day of June 2013. His employment was allegedly terminated in November 2019. From the evidence led before this court, claimant was above 65 years when he was employed by the first defendant, as shown by Exhibit L, claimant's biodata form. As at the time his employment was terminated, he was above 70 years. He has spent about 6 years in his employment with the first defendant. From the above provision of the reverse condition of service of the first defendant, claimant only worked for the first defendant for about 6 years. I agree with the submission of the defendant that is not entitled to retirement benefits allowance which people who are compulsorily retired are entitled to because they didn't work for 10 years straight in the first defendant, as provided for in section 1.4a III of the defendant's condition of service of the first defendant. I so hold. Something that the claimant has clearly made out his case and pleaded his month's salary to 31,000, so have been denied him since 2019. That Exhibit B, which is Federal Revised Condition of Service, clearly states in section 2.23, under which the salary does an annual salary increase shall be as for salary structure shall be granted to the employees at the anniversary of the employee's appointment and promotion, subject to availability. In section 2.24 of Exhibit D, claimant is entitled to fringe benefits as follows. So the fringe benefits are listed as housing allowance, transport allowance, leave bonus, exigency allowance, accommodation, loan, and lodge subsidy. And by section 2.28, section 2.28 is on leave matters. And I've reproduced the portion of this section. And then I said that from the evidence led before this court, I find that the claimant has not specifically led evidence to show, nor has it calculated the amount is entitled to under each of the above subheads. The other position of the law is that any party who wants the court to give judgment in his favor has legal duty to reach credible evidence to support his case before it can be entitled to judgment of the court. They will hold that there is no evidence before this court upon which they can grant above leaves of the claimant, and they accordingly refuse. And now talking about salary, something that by the claimant that he has made out a clear case, applied his salary to be the sum of 1,000 naira per month, which he has allegedly denied since November 2019. Reference is made to Exhibit B, which states under which of salary structure granted the employees at the anniversary of the employees' appointment and promotion. So reproduce the provision of section 2.24 and 2.241. And I said that no claimant has reproduced the above provisions of the first defendant's condition of service as it relates to his entitlement. He has not calculated the amount that's actually due to him under the section, or has he locally claimed any amount from the first defendant under the section. The third position of the law is that a party gets the onus to place credible evidence before the court to establish his claim before the court, as the court cannot judge a case based on the speculation. Claimant not having established these heads of claim, hereby refused by this court. I so hold. So enough that he has established the amount of his salary to be 31,000, his pleadings and evidence, including Exhibit F, needed to do more than this by showing how he's entitled to the above claims. So I reproduced a section 2.31 of Exhibit D on end of the year bonus. And I said that on the issue of end of the year bonus, claimant has a duty to calculate how much is legally entitled to be paid by the first vendor. Need evidence that he was not paid while some other employees of the defendant were paid. I hold that this court cannot grant relief for want of evidence. Claimants above claims are hereby refused. It has not led evidence to support them. So after in respect of gratuity, I stated the condition, I reproduced this section 1.4.3.1 of Exhibit C, and I said that it is obvious that the claimant has not satisfied all the above conditions so as to be entitled to the pay gratuity, because contrary to the conditions stated above, that claimant was employed by the first defendant on 11th June 2013, and his employment was already terminated on 9th of November. Claimant has worked for 6 years, thereby satisfying above conditions in part. However, has not met the condition that the employment must not have been terminated. So this is employment was terminated by the first defendant. I hold that claimant is not entitled to gratuity. And then in the set of claimant's claim for pension, he admitted under cross-examination that pension has been paid to him. And I therefore hold that this leave has been undertaken by events and damages, as claimants observed that malicious act of stopping the salary and empowerment by the president was a fraudulent breach of the employment contract between the parties, and as such, the claimants entitled to compensatory damage. My finding is that claimant's salary was stopped after his employment was terminated by the first defendant. However, since the court has earlier held that claimant's employment was wrongly terminated by the first defendant and is thereby entitled to damage, sum of 500,000 is awarded in favor of the claimant against the first defendant as damage. Also, since cost follows the event, cost of 500,000 and the entire judgment sum should be paid within 30 days of the delivery of this judgment. And I said the respect of the alternative claim of 5 million aggravated damages, I've heard that since the court has earlier awarded general damages in favor of the claimant, his claim for aggravated damages thereby refused, and this will amount to double compensation. And in conclusion, the court has said that the objection of the first defendant accordingly is thereby dismissed, that the first defendant has not terminated claimant's employment in accordance with the condition of employment between the parties, thereby rendering the termination as wrong. Awarded the amount of 500,000 naira in favor of the claimant as general damages for wrongful termination. And claimant's prayer for arrears of salary, allowances, gratuity, aggravated damages, and reinstatement are hereby refused. A cost of 500,000 awarded in favor of the claimant against the first defendant, and judgment sum will be paid by the first defendant within 30 days of the delivery of this judgment. The judgment is entered accordingly.
We are indeed very grateful for this well-researched and well-conducted judgment, sir. May God continue to bless the wisdom of the court.
Amen.
I'm very grateful, sir.
Amen. Thanks, sir.
Thank you so much. And thanks for your perseverance and dedication as well, sir. We appreciate you.
Yes, thank you, sir. Thank you, sir.
Thank you.
Okay. So where's the okay. So gentlemen, good afternoon, gentlemen. I mean, there's nobody there.
Good afternoon. Good afternoon, my
Yes.
lord. Yeah, we are
Actually, I stood down the other case, Alpha, Sunday. Were you able to get the counsel and the matter?
Yes, my lord. I called him to unmute his audio.
Okay, it's now
Hello,
around.
sir.
It's now around.
It's around. I think it's around, sir.
You know, I stood down. You know,
It's one barrister Godwin Okeke. I can see barrister Godwin Okeke online. I
have three judgments, yes. which I stood down for cases. Okay, I stood down 2 cases for judgment. After that, we'll now call the other case. Or should we call the other case?
Okay, sir.
Let's call that case. The one that
I think they are online.
Let me call the other case first. I'm trying to. Sunday, you say I'm missing you here now. If there's something I'm trying to check here, the rules of the court. Yeah. Okay. Let's bring it. Okay, this one. Just give me some seconds. There's something I'm trying to check. And the rules of the court. Sunday, if you were here, like you allow me to check it. So I'm trying to look at whether I can. Look at whether I can take the judgment today the same day. But not done it. Adoption. And then the same day. So, gentlemen, Mr. Igbabo and the other counsel on that. Actually, I'm not sure. I just wanted to confirm whether I can take adoption and judgment on the same day. Do you have any problem with that?
No, my lord.
No, my lord, I don't have any problem with that.
Has anybody done that before?
My lord, we have no problem with that.
Now
we have no problem with that.
The law,
yes, the law empowers my lord.
What I want to confirm is that whether it won't be against the rules of the court. Let me quickly check, please. Just give me.
The law empowers my lord to do so. My lord has 3 months from the date of adoption.
Yes, please. Yes.
Yes, my lord, the matter of who's on Napoli.
What?
The matter of who's on Napoli. Both counsel are online.
No problem. I'm coming to that case. There's something I'm trying to. Don't worry. Just give me 5 minutes to check something.
Yes, my lord.
I'll come back. I'll call the case now.
Yes, my lord.
What to call the case? Initially, you were not around. I guess.
Yes, my lord. We are having a network problem.
Okay, network problem.
Yes,
no problem. No problem. I will check now.
Yes, my lord.
I will check. I'll call the case. Just give me.
I'm grateful.
If it's something, I would open this thing.
We don't waste time. And the other one is judgment.
That's why I take it place down.
I don't want any call that will come in.
See, where any party for the address adopted and adjourned for ruling or judgment accordingly. Where does it cancel? One adjournment to the class. Is it after the thing? I think it's proper for me to. So you have advertised number. Advertisement. Take my phone. Check when you get advertised. When you see advertised, supposed to move to my list. Don't worry. When you get advertised, just let me go like that. Okay. Let me move it.
Mr. KK.
Mo fẹ́ sọ̀rọ̀ kí n bá àwọn sọ̀rọ̀.
Hello, gentlemen. Good afternoon, gentlemen.
My lord,
gentlemen. Yes.
Yeah, good afternoon, my lord.
So I've already clarified. So what I will do now is that I'm calling the case of Ozona Paul against CCECC. So let's take that adoption for those people.
My lord, my lord, my lord.
Yes, please.
I have a matter at the Court of Appeal at 1:30, and I'm leaving now.
No, you talk.
My lord, the claimant counsel, I'm the claimant counsel. I'm on.
I'm leaving now.
Yes. What's the name? Let me take your appearance, then you can quickly adopt, then you go to the Court of Appeal. Yes,
as a copy. As a copy. My lord, my name is Chief Godwin Okeke. Chief Godwin. My appearance is for the claimant.
Okay. Yes.
My lord.
Yes, please. Yes, sir. Yes.
My lord.
Yes, please.
I filed my written address out of time.
So those are coming as owners of the.
I filed my written address out of time. So there is an application.
Is that Mr. Okay, Mr. Suleiman Ajetumobi Abi?
Yes, my lord. Yes, as confuses. I filed my written address out of time.
Okay.
So I seek the leave of the Honorable Court.
Have you filed the motion to regularize it?
I have filed it, my lord. While my lord was in Ibadan, I have filed that. It is in the court file.
Okay. Okay. Yes. Take the application now.
Yes, ma'am. To save the time of the court, I seek the leave of the Honorable Court to move in terms of our application for extension of time to file written address. I seek the leave of the Honorable Court to move in time, sir, of our application.
The motion is dated when? The motion is dated.
It's actually dated the 23rd of October 2023.
And filed on the same date?
As copies is my lord. As copies is my lord.
Okay.
Yes.
Regularize him.
As copies is my lord.
I believe that Chief Okeke does not have any objection to that. Chief Okeke. Is he not there? Okay. Chief Okeke, do you have any objection?
I know no objection, my lord.
Okay. I'll just say order as prayed.
As copies. Now to the business of the day. The defendant's final written address is dated and filed.
Is dated and filed when? And filed, the network is not good. The data that filed when? Chief Okeke, you are not robbed.
23rd October 2023.
23rd of October
2023, my lord, yes.
Is it filed on the same date?
It's filed on the same day, my lord.
Chief, you are not robbed for sitting.
Yes, I'm very sorry, my lord. I'm even speaking from hospital bed. I just took this opportunity because I'm sorry, my lord. I'm speaking from hospital bed.
I wish you speedy recovery.
I'm grateful to my lord. Thank you, my lord. I'm very grateful.
Okay, so is that as far and the same day? So you seek to adopt same as
yes, my lord. The claimant final written address.
No, I'm talking about the defendant now. Has defendant finished?
Okay.
Defendant should take the written address. Defendant should adopt first. Has defendant finished adoption?
I don't know whether we have lost my little friend because I'm trying to help him so we can get through before network disturbs us.
Okay. I just said that we seek to adopt same.
As the court pleases.
Our argument. This
as
network supports our case. Okay, yes. Now, Chief, just take your own written address.
My lord, the claimant's final written address was filed on the 16th of August, 2023. 16/8/23.
Okay.
But it was dated 10th of August, 2023.
Dated 10th of August.
Yes, my lord.
So, you seek to adopt same?
Yes, my lord, I seek to adopt same as our final agreement in respect of this matter.
Okay.
And we don't need to belabor the court with adumbrations. I believe the court will read our submissions.
Yes.
So we urge the court to grant all our claims. As my lord pleases.
Okay. Case is stood down for judgment. So if you are not here, I will still read the judgment. But since you are here, the case is stood down for judgment.
As my lord pleases.
Down for judgment.
She wants to read the judgment immediately.
So that, yeah, give me the one for. Let me see. This Alabi. This Alabi.
That has been stood down for that one.
Yes, but please.
Yeah, so Mrs. Ufu Oma Nefe Alabi and DMT Mobile Portable Toilets Limited.
I've adopted. So,
my lord, the same appearance as the claimant counsel, CEO Ngoka Esquire.
I can now go and get a copy of the judgment.
CEO
Ngoka, CEO Ngoka, yes, sir. Ngoka.
For the claimant.
For the claimants, yes, sir.
And then the defendant's appearance for the defendant. The defendant's counsel is not online.
Let me quickly check.
I'll just say same appearance.
Same appearance, sir. Yes, sir.
Appeared before.
Yes, sir.
It appeared before. Today's network is that network is funny. So this is the judgment of the court. So judgment is quite lengthy. It's let me see. It has 9-page judgment. Look at more than that by the time I do the margin and everything. So this judgment of the court, as usual, are started by reproducing the claims of the claimant before the court. And then, of course, the next thing is that I summarized the submissions. The submissions in the final written addresses of the parties, starting with the defendant and then the claimant. So I summarized. So I will read the decision of the court. So that takes me to page 32 of the judgment with the decision of the court. I said that upon going through the claims in this case, the claims of the claimant in this case, defendant's response thereto, and his counterclaim as well as the submission in the final written addresses of the parties. This court holds the view that the issues for determination are as follows. 1, whether the claimant has proved her entitlement to the claims before this court, and so as to be entitled to have this court give judgment in her favor. And 2, whether the defendant's counterclaimant has proved its counterclaim before this court, so that to be entitled to the judgment of this court. And I say that the claims of the claimant before this court are 1, for the sum of 1,247,500, being the gratuity entitlement for 11 years service due to the claimant from the year 2011 to 2021. And then 2, release of the Toyota RAV4 Jeep with registration number FKJ 549ET, being the claimant's official car devolving to the claimant pursuant to the defendant's engagement policy dated 4th day of January 2012. And then the sum of 2,700,000 naira as general damages. So the law is said that in civil cases, the claimant bears the onus to prove his case, the satisfaction of the court with credible evidence, where the court can give judgment in his favor. The fact that the claimant was to discharge the onus on him, the defendant will be called upon to lead evidence in a matter of state. Also, the courts have distinguished between the legal body of proof, which is static and rests permanently on the claimant, and the evidential body of proof, which preponderates from the claimant to the defendant and is determined by the state of the pleadings. So I've relied on the case of Ega River against Osage and then Akonde against Adisa. The citations are supplied. I also relied on Section 131 of the Evidence Act. So under the subhead of gratuity, I've reproduced what the claimant stated as gratuity. I said it's stated in Exhibit 810, defendant's engagement policy dated 4th day of January 2012. Paragraph 3 thereof, that any staff that disengages will be entitled to 1 month's salary for each year. Stated that the rules for payment of the gratuity are that the employee must have served for a minimum of 5 years, and any staff that is served but has served for the statutory 5 years will qualify for gratuity. The anyone completed the year served after 5 years is calculated as a full year, and the policy for gratuity is stated to take retroactive effect from the date the individual staff assumed duty. From evidence led before this court, claimant was offered temporary appointment by the defendant on 22nd day of December 2010 per Exhibit A1 as an accountant. Her appointment was confirmed on 31st May 2011 via Exhibit A2, as she resigned from her appointment on the 29th of March 2021. Claimant has stated that she spent 11 years in her employment with the defendant. Clear from the evidence led so far, that claimant's gratuity is a monthly salary multiplied by the number of years spent in defendant's employment, as clearly stated in Exhibit A10. Also from the exhibit before the court, especially Exhibit A4, paragraph 4 thereof, claimant's gross monthly salary was the sum of 122,500 naira as at 31st of March 2021. Though it has been argued on behalf of the defendant that the policy for payment of gratuity has been stopped by the defendant, actually with the claimant that such policy that would deny an employee of benefit under the employment contract cannot be given retroactive effect. And I find that the gratuity has been earned before Exhibit B2 dated 5th May 2020, which purportedly notified all the defendant's policy was treated. If the claimant has left the defendant after 25 years, he would have been entitled to the gratuity. In any case, there's nothing in Exhibit B3 and B4 to show that lost service award was used to replace payment of gratuity as argued by the defendant. However, I hold that that claimant is entitled to pay gratuity by the defendant, and the defendant should pay the claimant the sum of 122,500 naira, which is our gross salary per month, multiplied by 11, the number of years spent by her in defendant's employment as a gratuity. Now, in case of the release of defendant's Toyota RAV4 operation number FKJ 549 to the claimant. Instead of this case, claimant has given evidence that by defendant's internal memorandum dated 7th day of August 2016, it was made to contribute. She was made to contribute and only contributed 10% of her monthly salaries for the maintenance of her official car for the relevant period Toyota RAV4 on the condition that it will be offered to the claimant as the first option purchaser. Whereas MD at the period in the person of Mr. Kaje Oleforo issued a directive through exhibit A6 and B1, which is dated 7/8/2016, that the contribution to official job car maintenance will be 10% for official cars and 8% for job cars. In Exhibit A9, stated that certain officers of the defendant are entitled to full cars, job cars, and official cars. Official cars are allocated to the serving senior management staff of the defendant, inclusive of the claimant. The condition for the allocation of the cars are that the brand new cars will be replaced after 5 years, while used cars will be due for replacement after 3 years. Users of the official cars were required to contribute minimally to the maintenance of the car. That in this case, the official car develops a serious fault. The management may decide to dispose to replace it for 3 years. That in case the official car develops a serious fault midway, management may decide to dispose or replace it before or within 3 years at a price to be decided by the MD and the accountant of the company. Of particular importance is the disposal procedure for the job and official cars as stated in Exhibit A9. In Exhibit A9, okay, sorry. Of particular importance is the disposal procedure for job and official cars as stated in Exhibit A9 to the effect that, quote, the job and official cars will be offered to the primary users as a first option at 8% of the purchase value. Where their users do not show interest, they will be offered to other staff as second option at 50% of the purchase value. When those staff shows interest, they will be sold to the public at a negotiated price. End of quote. I find I hold that claimant has led credible evidence to show the standard practice. So the standard practice of the defendant in asking users of official vehicles so that the claimant to contribute 10% of their salaries to the maintenance of the vehicles, and that she has contributed 10% of her salary to maintain the Toyota RAV4, which she is claiming entitlement to in this case. In accordance with the circulars reproduced and analyzed above, I hold the view that it will be unfair and inequitable for the claimant to be denied the purchase of the car by the defendant, since the claimant has offered consideration in quote now, towards the purchase of the car. I also hold that she has the right to be given the right of the first option to purchase the RAV4 car. This court is mandated to apply both law and equity in any case that is brought before it. And as rightly submitted by the claimant, accepting defendant's submission that claimant will only be entitled to the right of first purchase if the defendant has decided to sell the vehicle at all, and that it has not decided to sell the vehicle yet, and that claimant's right to purchase cannot arise until the RAV4 is offered for sale. We amount to asking or requiring the claimant to wait indefinitely. I hope that this will not be in the interest of justice in the circumstance of this case. And so that the defendant should release the Toyota RAV4 with registration number FKJ 54980 to the claimant after she must have paid the relevant fees to be calculated by the defendant based on the percentage stated on the condition of employment between the parties in respect of the vehicle, which is 8% of the purchase price. General damages. Claimant has also asked for 2 billion as general damages before this court. The position of the law is that award of general damages is at the discretion of the court, as the parties asking for it does not need to prove it. However, the discretion of the court must be exercised both judicially and judiciously in the best interest of justice. I've looked at the circumstance of this case. I would feel that since the court has ordered most of gratuity to the claimant and release of the RAV4 car to her, she must. So after she must have paid the requisite fee, it will not be in the interest of justice for the court to award general damages. Now, so hold the application for general damages thereby refused. And that takes me to the counter claim. I've reproduced the counter claim of the defendant. The claimant has given evidence that she paid this sum to the defendant. She has tendered Exhibit A11, which is the payment confirmation for the sum of 112,000 naira, which was allegedly received from the defendant, from the claimant by the defendant, as payment in respect of the Toyota Corolla with registration number J263CY, which was the first official car allocated to the defendant by the claimant. In paragraph 2 of the exhibit, stated that all documents required for her to change the ownership of the car have been given to her. Also, Exhibit A12 is the letter dated 10th day of July 2017, whereby one Richard Ajobere, defendant's logistics manager at the time, through which the claimant was introduced to the licensing officer of the licensing office Lagos. The contents of the letter is reproduced as follows. Dear Sir, change of ownership. This to certify that the vehicle with the underlisted details as been sold to Mrs. Ufo Manefe Alabi. Make of the vehicle Toyota Corolla color silver, VIN number, chassis number 2TIBR32E003C035590. All relevant documents required for you to effect change of ownership has been given to him. Say, thank you for your cooperation. End of best regards. I said, signed by Richard Ajobere, logistics manager. The action of the logistics manager is in line with SBB 1. There is presumption of regularity in favor of the exhibit, and there are no alterations on them. I find that above exhibits were affirmative that claimants actually paid for the Toyota Corolla car, and this prompted defendant's logistics manager to write to the licensing office and affirm that all documents necessary for change of ownership had been given to the claimant. To my mind, this is admission on behalf of the defendant that it has been paid in money. And I strongly believe that this would not have been the position if the allegation of the defendant's counsel was true. And from the evidence extracted from the claimant under cross-examination, the defendant operates about 4 different accounts and only tendered one of the accounts to show that claimant did not pay the sum. In my view, the court will only be able to hold that the allegation of the defendant is true if all the documents, all the defendant's statement of account are exhibited before this court. I therefore hold that the defendant has not led credible evidence to show that claimant did not pay for the Toyota Corolla, and is claimed for the sum of 102,000 thereby failed. Now, tax liability. Defendant has also claimed the sum of 2,251,767 kobo as the tax liability incurred by the defendant counterclaimer due to the negligence and connivance of the defendant to the claimant, defendant to the counter claim. Connivance of the defendant to the counter claim in failing to draw the payee tax from Mr. Kajenta Odoforo's salary from January 2015 to December 2016. Defendant counterclaimant's reason for counterclaiming for the above sum is that the claimant connived with Mr. Kajenta Oleforo. The SY MD of the defendant, by failing to deduct the payee tax of Mr. Oleforo's monthly salary from 2015 to 2016 financial year, which made the defendant counterclaimant to run into tax liabilities in the sum of 2,251,767 naira. What the counterclaimant is saying is that claimant connived with Mr. Oleforo to evade tax payments to the appropriate regulatory authorities. It's an evidence that Mr. Oleforo joined the defendant as a consultant and was already paying tax elsewhere before his appointment. And it would amount to double taxation if any tax was removed from his salary again. Mr. Oleforo actually asked claimant not to remove any tax from his salary for this reason. So submitted by the claimant, connivance to evade tax is criminal allegation. And settlement and settled position of the law is that this allegation must be proved beyond reasonable doubt. My findings in respect of this head of counterclaim are as follows. The 2015-2016 financial year, where the claimants are alleged to omit to deduct the payee tax from salary of Mr. Oleforo is at least 5 years before claimant's resignation. I wonder why the issue was just being raised after the resignation of the claimant. I tend to agree with the submission of the claimant that this is an afterthought on the part of the counterclaimant. Since the allegation of connivance to evade tax leveled against claimant to the counterclaim is criminal in nature, and the claimant has not, and it's criminal in nature, and it has not been proved. It has not been proved beyond reasonable doubt. The court cannot hold her liable for the sum of 2 million 251,267 naira 57 kobo as tax liability incurred by the defendant counterclaimant in respect of former MD Opeloye. I find it very interesting that claimant will deliberately connive with Opeloye to evade tax when she had nothing to gain from such action. Despite of the submission of the counterclaimant, rather, there are 6 defendants of the counterclaim only filed a defense of the counterclaim and did not file a written statement of notes thereto. They seem to have admitted the counterclaim. I disagree with this submission on the ground that the position of the law is that a counterclaim is an independent case which must be proved by the counterclaimant in order for it to be entitled to judgment. We only succeed on the strength of the evidence led with in support thereof, not on the weakness of the defense. Even if the claimant has not filed any defense to it at all, the counterclaimant still bear the onus to establish the counterclaim, the submission of the court, for the court can do judgment in its favor. For the aforementioned reason, I hereby hold that the counterclaimant has not established that defendant to the counterclaim has connived with Mr. Opeloye not to deduct tax, not to just pay tax from his account for the relevant period. And since the main claims of the counterclaimant have failed, counterclaimant claims for interest automatically incurred. I so hold that their counterclaims accordingly dismissed. In conclusion, this court hereby holds that the defendant should pay claimant the sum of 122,500 naira as gross salary per month as at March 2021 multiplied by 11 as a gratuity in this case, so that the defendant should release the Toyota RAV4 with registration number FKJ 54980 to the claimant after she must have paid relevant fees, which should be 8% of the purchase price of Toyota RAV4 to be calculated by the defendant based on the percentage stated in the condition of employment between the parties in respect of the vehicle. That it will be in the interest of justice for the court to award general damages for the claimant in this case. Other claims have been granted. And as since cost follows event, cost of 500,000 is awarded in favor of the claimant against the defendant. Our defendant's counterclaim are hereby dismissed totally. Judgment is inside the contract.
My Lord, we are very, very, very grateful to the court for this judgment. It is full of scholarship and erudition, and is a hope. It actually has proven that the court is the hope of a common man. May the Lord continue to bless the court and grant her more wisdom to dispense the duties that her office requires. God bless the court.
Amen.
Yes.
Thank you, Francis.
Yes.
Yes, so. Yes, the next case I want to call is the case of Andrew Agbeha. Andrew Agbeha is about Umejibo. Yes, I'm going to take appearance now. Not the one I just
Yes, my lord.
I just took this. I just took this,
my lord.
This one just okay. Okay. Yes, please. So
SC Umesi, my lord. I appear for the claimant.
Okay.
Much obliged, my lord.
Okay.
May your lordship please. R.O. Igbabo. R.O. Igbabo for the defendant.
Okay. Just say that judgment is taken today by me. We'll soon finish. So, this judgment of the court, as usual, I started with laying out the claims before the court in the cognitive process of the claimant, the processes of the claimant, with reference to the exhibit, and then the next thing is I summarize the submissions, the finalizing addresses of parties, starting with the claimant, and then this takes me to page 13 of the judgment, which is the decision of the court. So I said that we're going through the claims of the claimant before this court, defendant's response thereto, as well as the submission of the fine on submissions in the finality addresses of the parties before this court. The court holds the view that issues for determination in this case are as follows. One, whether from the evidence, before this court, claimant has shown that he's entitled to the relief sought by him in this case. And two, whether the evidence of the defense witness before this court is hearsay evidence. And three, whether or not defendant has considered is a juristic person for this honorable court. Issue one, the position of the law is that a contract of employment is the bedrock of any employment relationship, and that parties are bound by any employment which they willingly entered into. Furthermore, the law has been established that when an employee alleges that his employer has breached the conditions of employment while terminating his employment, he bears the onus to not only to bring the terms of employment before the court, but to also prove how same was breached. I've relied on some cases, I've back to Nigeria PLC against Oshisoya, against Anigi, against First Bank of Nigeria PLC, and then OVVA against UBA PLC, and ITEL against Opeloye, so many other cases there. So, and there's no doubt in this case that claimant's condition of employment with the defendant is contained in the exhibit A1. That's claimant's letter of employment as a tutor, dated 8th of July, and letter of confirmation dated 2nd December 2014, exhibit A4. Claimant has alleged that on 23rd day of October 2017, the first defendant terminated his employment without regard to the terms and conditions of employment contained in the appointment letter dated 8th day of July 2010. With respect to this allegation, the defendant has given evidence that claimant was dismissed from his employment for misconduct, and that claimant had previously exhibited conduct inconsistent with the school values and objectives, as a result of which claimant was issued with several queries for habitually coming late to work, handed down a suspension letter and an invitation to appear before a panel of inquiry via a letter dated 14th April 2014. All of the query letters, suspension, and letter to appear before a panel of inquiry are admitted before this court as exhibit. Defendant has led evidence that dismissal of claimant for misconduct has precluded him from accessing his final entitlement. So I've relied on the case of Jumbo against Petroleum Equalization Fund Management Board. But the third position of the law is that an employer can dismiss an employee on the ground of misconduct without notice. The word misconduct is conduct of grave and weighty character as to undermine the confidence which should exist between the employer and employee. I've learned the case of Edufeco against Pfizer Products Limited. It's not an issue that claimant was dismissed from his employment with the first defendant as one of the relief sought by the claimant that this court should order that the dismissal should be changed to termination. However, he has alleged that the first defender did not comply with terms of the employment while carrying out the dismissal. He has not led specific evidence in respect of the allegation of non-compliance on the part of the defendant. I wish to reiterate that the terms of employment between the claimant and the first defendant are stated in Exhibit A1 and A4. Exhibit A1 contains the term as to 3 months notice of termination at the end of the term, or payment of a month's salary in lieu of notice, terminal pay of 10,000 for each day to any staff who has spent at least 5 years, and traveling allowances for employees staying outside Abeokuta, amongst other conditions. First defendant has tendered exhibits A6, A7, A8, B1, B2, B3, B6, B7, and B9, which include queries, letter of suspension, claimant's application to decline appointment, that is first defendant's instruction, and invitation of the claimant to appear before the panel of inquiry. I find that these are clear evidence of misconduct on the part of the claimant in the course of his employment with the first defendant. Claimant has alleged that the first defendant probably backdated a letter in reply to letter to the management of the first defendant to decline his appointment as the chairman midterm examination committee, which is dated 20th day of October 2017 to 18/10/2017. The first defendant refused him exit from the school premises to 5 p.m. instead of 4 p.m. and that he was booked to replace the glasses of a student that got broken. Refusal to obey a lawful authority of the employer by the employee is a good ground for dismissal by the employer. First claimant has admitted that he wrote to decline his appointment as the chairman midterm examination committee. From this and various other reasons earlier stated, I hold that there were good reasons for which claimant was dismissed from his employment with the first defendant. On the other hand, I hold that the claimant has not proved the allegation of fraud against the first defendant at the standard of proof is that of beyond reasonable doubt. Also, I hold that the claimant has not proved that he was detained in the school premises by the first defendant satisfaction of the court. Even if the defendant should ask the claimant to collect a letter, that does not mean that was detained as he had the ability to decide whether to stay or leave the place. I agree with the submissions of the first defendant that since the claimant was dismissed from his employment with the first defendant, he is not entitled to any terminal benefit. As a result, I hereby hold that claimant is not entitled to the terminal benefit he is claiming in this case. His claim for terminal benefit, which is payment of 10,000 naira for each year spent by him for the period of 7 years, and the declaration in respect of his detention in the school premises of the first defendant are hereby dismissed. Now that takes me to leave bonus. Leave bonus. Claimant has asked this court for a declaration that the claimant having worked the employment of the defendant for a period of 7 years is entitled to leave bonus of 5% of annual gross salaries and allocation and allowances rather, totaling 144,433 naira 20 kobo, covering the period of 2011 to 2017. The actual position of the law is that a dismissed employee is entitled to be paid his salary to the last day and any outstanding leave pay. Claimant has led evidence that first defendant only paid him sum of 10,000 leave bonus instead of 24,000 leave bonus in 2014 alone, and other leave bonuses are outstanding. In his evidence, defendant never denied that he did not pay. Never denied that he did not pay claimant's leave bonus, but only, let me just say, the defendant never denied that, they never stated that it paid, so that another interpretation is not interesting. So the defendant never denied that, they never stated that it paid the claimant his outstanding leave bonuses, but only said that the right of the claimant to take annual leave would only arise if any employee should apply for it, and that since claimant did not apply for leave, he could not be paid any leave bonus. He stated further that the defendant would only become obligated to pay leave bonus if the employee should apply for it, and that when an employee applied for leave and the application is declined, the employee will be paid money in lieu of note. There's no doubt that this is an admission on the part of the first defendant that claimant was not paid his outstanding leave bonus. First defendant never denied the amount of 144,433 naira 20 kobo being claimed by the claimant as the outstanding leave bonus. Rather, it is deemed to admit the stop. I do not agree with the first defendant that claimant is only entitled to leave bonus when it applies for it as well. Applies for it. As the right for leave is a right that is automatically accrues for an employee under the Labor Act and must be taken within the year it is earned, and it may be deferred for the next 24 months only with the agreement of the employee. It is illegal to pay the employee his basic salary in lieu of annual leave instead of allowing him to go for the leave. Section 14 of the Labor Act provides for at least 6 working days as annual leave for workers or employees with full pay. This may be increased as much as 30 days depending on the organization. It's an evidence that the claimant has worked with the first defendant for a period of 7 years before he was dismissed from his employment. Claimant has also led evidence that his leave bonus is 5% of gross annual salary in the sum of 144,443 naira 20 kobo. In the circumstance, first defendant is ordered to pay claimant his cumulative leave bonus and the sum. October salary, that's the subtitle. Claimant has prayed the court for an order directing the first defendant to pay him is October salary, over 2017 salary. It's in evidence that though claimant was dismissed on 20th day of October 2020, he was paid half salary for the month of October. He had the duty to plead and lead evidence as to the amount he was entitled to for the month of October. I hope that there's no evidence before this court upon which to find specifically as to the remaining outstanding salary of the claimant for the October 2017. The sort of damages which claimant has paid for, has presently paid for 2 million damages. This portion of the law is that general damages are already based on the discretion of the judge. But this discretion must be exercised judiciously. Law is stressed that in employment matters, generally, general damages are only granted when the occasion warrants. However, that this is not the case in which the court can grant general damages. And I hold that there's no evidence before this court upon which it can find specifically as to the there's a mistake. So I hold that this is not a case in which the court can grant general damages, and the prayer for general damages is accordingly refused. Now, in the case of claimant's pension, claimant has sought for another directing the second owner to pay to him 25% of all the pension contribution in accordance in the account of the claimant, pending the attainment of the retirement age of the claimant at the current regime of 10% employment contribution and 7.5 employment contribution employee pension contribution. However, in the course of trial, claimant has admitted that his pension was, his pension has been paid to him. I hope that this claim has been overtaken by event. The result of issue 2, as whether the evidence of defendant before this court is a hearsay evidence. Generally, hearsay evidence is not admissible to establish the truth of what is stated therein. Section 40, Section 37 of the Evidence Act 2011 as amended. I'm tired. Claimant's counsel has submitted that since CW1 was not in the employment, what's the problem? Okay. Claimant's counsel has submitted that since CW1 was not in the employment of the first defendant when claimant was there or when his employment was terminated, our evidence was hearsay. However, I agreed with the submission of the first defendant that since a company can only act through its former agent or servants who can give evidence in its favor, even though he did not take part in the transaction, the evidence will be admissible. I therefore hold that for this reason, the evidence given by W1 cannot be regarded as a hearsay. Also, respect of issue 3, whether or not defendant has constituted is a juristic person before the court. First defendant has stated that it is not a juristic person because the proprietor of Tied Up College is Dr. Abayomi Jiboku, who is now late, and the college is now being managed by the Manson. What's important to this court is that the claimant was employed by Tied Up College. As a result, I would that the first defendant properly sued by the claimant first case. In respect of amendment of the claimant's process, by the motion on notice dated 27th of June 2022, the claimant sought to amend his process before this court of grant that claimant had changed his counsel in this case. The first defendant has argued that claimant did not amend his process and that this is obedience to the order of court. I have gone through the application of the claimant in question. I hold that a party who changes counsel does not need to amend this process. All he needs to do is to give notice to the court that he intends to change his counsel, and that will survive. So I hold that the argument of the defendant is of no moment and save its countenance. And then the defendant's counterclaim. I've read what the first defendant referred to as counterclaim. And I hope that is not counterclaim in the real sense of it, as if it's implied to the defense of the first defendant, and the counterclaim is accordingly struck out. In conclusion, this court hereby posts as follows: that the claimant having been dismissed from his employment for misconduct is not entitled to terminal benefit. The first defendant is ordered to pay claimant a cumulative leave bonus in the sum of 144,433 naira 20 kobo. And the sums already end. But there's no doubt, there's no evidence before this court upon which to find basically as to the remaining outstanding salary of the claimant for the month of October. Claimant's claim for general damages is refused. Since in the course of trial, claimant admit as admitted that his pension has been paid, to him, I hold that the claim has been overtaken by events. And since a company can only act through its former agent or servant who can give evidence in its favor, I hold that the evidence of guilty of V1 is not a hearsay. I also hold that the first defendant is properly sued by the claimant. Also that the party who is changing his counsel does not need to amend this process. All he needs to do is to give notice to the court that intends to change his counsel. That will suffice. Also that the first defendant's counterclaim is not counterclaim in the sense of it, and since it's already applied in defense of the first defendant, and since accordingly struck out. And since cost follows the event, cost of 200,000 is awarded in favor of the claimant against the defendant. And judgment is entered accordingly.
As the companies, we are most grateful, my lord.
As the companies, my lord, we are very grateful, my lord, for your well-considered ruling, a judgment in this matter. And we are very grateful also for the indulgence for accommodating us thus far till now we have ended this matter. We say, may the Lord continue to enrich my Lord with wisdom and knowledge. Thank you very much, my Lord.
You're welcome. You're welcome. I'm very tired. Yes, my God. Just like I still have to read these things, make sure that they are proper. Errors, correct them, and then defend them. Yes, the last but on the list case is the case of Uzonna Paul and CC Nigeria Limited. Yes, at council stay there. They are not around. Okay. Based Igbabo Esquire and Mr. Omesi, you are the charge.
Yes, my lord.
Yes, my lord. Thank you very much, my lord.
I've told them that I'm going to say this. I can take judgment or take judgment as read.
As the court pleases.
Yes. Yeah. Yes. This so the judgment in this case is hereby taken as read. And in conclusion, the concluding part of the judgment is that this court hereby holds as follows: that the defendant should pay claimant his basic salary for 7 months in the sum of 108,591 naira. transport, feeding/meal allowance, medical utility tools, leave allowances in the sum of 237,400 naira. Also, claimant is entitled to be paid his basic class salary in the sum of 15,713 naira in lieu of notice. Further should pay the claimant cumulative sum of 682,070 naira as his benefit. There's no evidence upon which this court can base the claim for pay or layoff. The entire judgment should be paid within judgment sum should be paid within 30 days of date of this judgment. And since cost follows event, cost of 250,000 awarded in favor of the claimant against the defendant. A judgment is entered accordingly. So Sunday. Let me exit. I want to exit. Better. I know it's very okay. I know it's very nice. Who is very nice? Is the host. No, what I'm able to tell is that taking as you read the clarity, the full judgment, everything is very strange. So, this case now, this judgment, I started this judgment of Chooks Uzona Paul and Steve ECC Nigeria Limited, started by summarizing the claim, presenting the claim of the claimant, summarize the submissions in the final written addresses of the parties, starting with the defendant. I want to read the full judgment, starting with the defendant to finish. To the claimant, summarize their submissions. And that takes you to page 18 of the judgment, which is the decision of the court. Okay, we're going through the claims of the claimant before this court as endorsed on its general form of complaint and other originating processes. The federal response thereto, as well as the submissions in the respective final written address of the parties. This court holds the view that the issue for determination is whether the claimant has established his claims before this court, so as to be entitled to have this court give judgment in his favor. I said the position of the law is that standard of proof in a civil case is on balance of probabilities based on the preponderance of evidence, whereby the judge puts the credible evidence or the parties on the other side of the imaginary scale of justice and give judgment in favor of the party. The evidence weighs more. Also, the law is settled that in civil proceedings, the legal burden of proof is on the claimant as he bears the burden to establish his case to the satisfaction of the court with credible evidence before he can be entitled to judgment of the court in his favor. The position of the law is that he who asserts must prove what he asserts, and that the burden of proof is always on the party who will lose if no evidence is adduced on the other side. However, after the claimant was have discharged the legal burden of proof, the evidential body of proof will now shift to the defendant to disprove the evidence of the claimant. What legal burden of proof is static and does not shift, the evidential body shifts from one party to the other, as is determined by the state of pleading. The case of Opeloye against Ogunbowale and Mogaji and Odofin. The citations are supplied there, and also section 131 to 136 of the Evidence Act 2011 as amended. Law is settled that contract of employment is the bedrock of any employment relationship, and the parties are bound by the terms of any agreement they voluntarily entered into. Already on the case of AG of Rivers State versus AG Akwa Ibom State. Citation is supplied. Also, Also, the law is tried that where in any case before the court, an employee alleged that terms of employment was breached in any way by the employer, as it is to place his terms and conditions of employment before the court, and lead evidence of how they were breached. The case of RG and CBD. For going to the conclusion of the claimant, the evidence that both oral and documentary are found as skills before this court. On the other hand, defendant's evidence, why the defendant has alleged that the recent claimant's employment was terminated, that he abandoned his work or duty for a period of 6 months, the evidence before this court is not consistent with this allegation. The reason given for the termination of the employment is that his services are no longer required by the company with effect from 22nd July 2020. So the letter is not dated. However, the reference number of the letter of termination is CCIB/2017/123.2nd July 2020. The 2nd of July of 23rd. So my understanding, this reference has shown the date of the employment of the claimant, which is 2017. The date of termination, which is 23rd of July 2020. What this means that the letter was issued on the same day of termination, which is 22nd day of July 2020. 23rd day rather of July 2020. This confirms the evidence of the claimant that he was not given 2 weeks notice as stated in the letter of employment at Exhibit 1, which contains his terms and conditions of employment. Note that the defendant did not give claimant 2 weeks. 2 weeks notice stipulated in the condition of employment between the parties, and that this has rendered the termination as strong. Further, I find that hold that the fact that claimant's employment was terminated instead of summary dismissal shows that defendant's evidence is consistent with the allegation that claimant abandoned his duty post. Also, in paragraph 3 of the termination letter, defendant states that claimant is entitled to all outstanding payments for the current month through the area. This also shows that claimant's employment was not terminated due to any misconduct. From the evidence before this court, claimant was employed in 2017, while his employment was terminated in 2020. At his time of employment in July 2017, claimant's salary was 13,300. However, on his process, claimant stated that his salary was 15,713,000 as at the time of his termination, and this sum is admitted by the defendant as his basic salary. Also, in letter of termination, defendant has admitted that claimant was being owed some arrears of payment. The position of the law is that first admitted need no further proof. So, defendant has stated that claimant was offered 2 months salary in lieu of notice, but refused to accept it. Defendant has not stated the mode of alleged offer. I believe that the usual mode of payment of claimant salary by the defendant should be payment into his account. I find this piece of evidence led by the defendant to be very incredible. Claimant has adduced credible evidence to show that he is entitled to his claim before this court, including his basic salary in lieu of notice, arrears of allowances, and the balance of his pension fund as claimed by him in his originating process before this court. As a result, this court hereby holds as follows. 1. That the defendant should pay the claimant his basic salary for 7 months in the sum of 108,591 naira. 2. That the defendant should pay claimant his housing, transport, feeding, meal, medical utility tools, and the allowance in the sum of 357,100 naira. Also, claimant is entitled to be paid his basic salary in the sum of 15,213 naira as payment in lieu of notice. 4. Claimant should pay claimant cumulative sum of 282,070 naira as benefit. 5. There's no evidence upon which this court can base the claim for pay or layoff. The entire judgment sum should be paid within 30 days from the date of this date. And since the court follows the court of final awarded in favor of the claimant, this is final. Judgment is entered accordingly. So I guess you all well done. This is exit. Sunday.
Yes, my lord. Okay, my lord.
Ojúlé yẹn ti Ìbàdàn area. Wálé o.
Yeah, good man. You did a great work, my lord. Yes, ma.